I would kindly ask Martin, Maila, and Alexander to open their screens. Yes, camera. Thank you, Alexander, and hello also to Jelena, Saiful, and Abdi. And to Alexander, I'm sorry for this delay of half an hour, but it looks like actually whether it was the reason or not, but somehow the classroom is empty here at the law faculty in Belgrade. And I have to say I'm very much disappointed about it. And not only myself, but other colleagues, Professor Ivana Krstic and Bojana Čučković, we were talking about it, that something that is supposed to be an exception, which is online participation, has become a rule. And I'm not sure for how long we're going to accept it, just to inform you about all that. But all the more in this context, it would be nice at least if we could all see each other. So I kindly re-ask Martin, Maila, and Abdi to keep your screens open so that at least we can see each other. I mean, it's extremely difficult to give a lecture when you don't have interaction, a communication with the audience. The purpose of the lecture is actually to share the knowledge, not to speak, for the sake of speaking. So in that sense, I would kindly ask you, all of you who can come, to come regularly to the classes at the law faculty, and those who cannot, who are not in Serbia at the moment, who exceptionally cannot attend classes physically, who cannot be here present to, Okay, thank you, Martin, for the information.
Sorry, Professor, I'm usually coming all the time, but because of the delay today, I have something after the class and I couldn't make it.
Mm-hmm. Okay. Anyway, let's start with the class. So today's class is going to be about the gender equality jurisprudence of the European Court of Human Rights. So it's about the case law of the European Court of Human Rights related to the gender equality. Now, the presentation is structured in the following way. I will tell you a few points about the European Court of Human Rights and its case law in general, so that okay, thank you, Maila, for the information. So I will tell you first a few points about the case law of the European Court of Human Rights, meaning the general information about the court. We have students with us who are not from Europe, and also those who are from Europe. It is good to remind ourselves so as to understand the weight of that case law, what kind of effect it has, what kind of status it has, in what sense it is important for the dissemination of the human rights law, and in this concrete case of gender equality law. So that will be the first point of today's presentation. The second point is going to be about exactly the anti-discrimination case law, about actually the standards which the European Court of Human Rights has established with respect to the anti-discrimination law. And thirdly, we will be talking about the typical cases involving gender equality in the context of the court's case law. So we will see what are those issues in which the questions of gender equality appear, and how the court deals with those issues. So we will see what it means for a court to be proactive and engaged in protecting gender equality and furthering gender equality. It is not to say, we'll enter into those details a little bit later on, it is not to say that the case law of the European Court of Human Rights is perfect from the perspective of the protection of gender equality. And one of the reasons explaining why it is not perfect in terms of gender equality, and how it could be better in serving that goal, that ideal, and that standard. The explanation will come and it will be understood, it will be more clear after I explain the functioning of the whole system, of the European system of human rights protection. Hence, this introduction related to the European system of human rights protection. So this system of the European human rights protection was established after the Second World War. It was established in 1950. The European Convention on Human Rights was signed, and in 1959, the European Convention on Human Rights entered into force. 1 year before signing of the convention, in 1949, the Council of Europe was established, an organization which was established with the purpose to further the democracy, human rights, and rule of law in Europe. The idea was clear in the sense that, as we already mentioned it last week, the new philosophy of international relations. And yes, okay, no, it was missed the room. Doesn't matter. So it was a new philosophy of international relations, new philosophy of international law, and hence a development of European law in this context of European human rights law. The idea was clear, and the message was, in that sense, clear as well. It was not sufficient just to have the documents such as conventions, declarations, as we spoke of it previously in the context of human rights law. It's not sufficient to have the constitution. You have to also have the court with the power to protect the rights and liberties stipulated in those documents. Hence, the adoption of the European Convention on Human Rights, which provides for the European Court of Human Rights. So, court was part of the mechanism of the protection of human rights from the very beginning. And not only the court, but there was also a commission which was established together with the court. And the commission itself, those two bodies, commission and the court, were the key mechanisms of protection of human rights after the Second World War, as of 1959, when the European Court of Human Rights, when the actual convention, as I said, entered into force. In 1998, 11th protocol was adopted to this convention on human rights and freedoms. And as a result of that protocol adopted in 1998, the commission was abolished and only the court stayed, which was a further, which was intended to further strengthen the mechanism of protection of human rights, as the commission was in a way a specific body which did not provide that level of human rights protection as the court did, and the court still does. So, as of 1998, we speak of the European Court of Human Rights with its seat in Strasbourg as the main court of the protection of human rights, the main body for the protection of human rights in Europe. And the convention, which is the founding document establishing human rights of civil and political nature, and also establishing the court, European Court of Human Rights, is an international document. So that is clear from the perspective of international law. It is a document which at this moment has 46 member states, 46 high contracting parties. Also, until 24 February 2022, Russia was a high contracting party to the European Convention on Human Rights. But as a result of its aggression on Ukraine, it was expelled from the Council of Europe, and hence it also lost its status of the high contracting party. Belarus has never been a member state to the European Convention on Human Rights. So at the moment, there are 2 European countries which are not member states, which are not high contracting parties, and Russia being certainly, in terms of its space and the population, a very important member, which we lost in the meantime. This very fact that a member state can actually either withdraw itself or be expelled shows in itself actually manifests one side of this system, and that is an international side of this system. So there is no doubt that the Council of Europe is an international organization, and in that sense that being a member high contracting party to the European Convention is not an obligation. Everyone can choose to be part of it or not. And also, as we could see, Council of Europe expelled Russia, but at the same time, in a simultaneous action, Russia withdrew itself from the Council of Europe. So that is also possible. And I think I mentioned last week that there are also political parties in the UK right now who are suggesting the possible withdrawal of the UK from the convention system. I think these are still speculations, but the mere fact that it is mentioned, that it is raised as a potential issue, is very worrying. Since the membership in the Council of Europe and the status of the high contracting party obliges in itself member states, so that is a sort of obligation. And although we are not always happy with the way the case law is applied by the member states, it is certainly it is for sure that the case law, the convention case law, is much more observed and respected, and hence those human rights, if a country is a member state, rather if it is not. So this is why the membership is important, and if it starts crumbling, then I fear that some other countries could also consider the possibility of withdrawing from the convention system. This is very, what I'm speaking right now is kind of surprising in itself, and it's kind of, it was unimaginable when I started teaching this course, European Human Rights Law, within other programs, because we have been, since Second World War, in this constant line of progress when it comes to the protection of human rights. So the power of the European Court of Human Rights is in itself speaks for itself. If from the external point of view, it does look like an international document, and the European Court of Human Rights looks like an international court, internally looking, and this is the part that I will particularly talk today, from the perspective of the relationship between the Strasbourg court and the member state courts, it looks like European Court of Human Rights is a sort of supranational constitutional court. So it is in a complete contrast. Everything that I'm speaking right now, this possibility of the whole system to crumble, and to disintegrate is in sharp contrast with the status which this court enjoys in the domestic legal system. So this actually presentation and this talk is about the weight of the convention case law. From the outside, once again, from the external point of view, it looks like an international document. In order for it to enter into force, countries have to sign it, they have to ratify it. They also have a right to have one judge per member state in the court. But and so it looks from the outside like it is an international court. However, already speaking about the judges, and it is true that there are in total 46 judges at the court, European Court of Human Rights in Strasbourg. At the same time, one has to say that these judges are not representatives of the member states. They're not there acting as a sort of agents of the member states. They are appointed in respect of the member states. So they're appointed in respect of the member states. It is important to have one judge from each member state because in many cases, the issue of domestic law and the content of domestic law may appear, and the question of application of the convention in the domestic legal systems of the member states may also appear, and hence it is important to have someone from the member state who can explain the specificities of the legal system of that member state to other judges within the system. Yes, Jelena.
But states are the one who are suggesting the candidates, right?
Yes, the states, they participate in the process. They
candidate them. Or they choose it within the state and then like just send that person.
The states, the rules on the appointments and the process of appointments of appointment of judges are very scarce. So they're very limited in number. Those rules, and they are. What I want to say is that states have a very wide margin or relatively wide margin of maneuvering in deciding who will be the candidates. The European standards, the Council of Europe standards with respect to the selection of the judges imply that this process has to be transparent and it has to be open. It has to be public. These are some minimal rules imposed by the Council of Europe. What else is implied is that the member states should open a vacancy, should announce it in its domestic media by sending letters to relevant institutions such as courts, faculties of law, etc., and that they should conduct a transparent and open process of selection of 3 candidates. As a result of this decades and decades long process, in the context of gender equality as well, we have established a rule which was not present and which is not written anywhere in any document, and that is that at least that the candidates may not be of the same sex, that there should be at least one candidate of the opposite sex as compared to the other 2. Whether it's going to be 2 men and 1 woman or 2 women and 1 man, it's a matter of the context and the circumstances. And also what we have established over time is the rule that all candidates, those who are selected by the member states to be the candidates, have to have a relatively same weight. So they have to have specialization, or they're expected to have specialization in European human rights law or international public law. They should know the domestic legal system. So constitutional court judges, Supreme Court judges, law professors, positive law professors are ideal candidates there are also some attorneys who become candidates and who are also appointed as judges.
Sorry. Yeah, I was asking that because I'm just interested in reality. How much is it connected with the politics, actually?
Yes, it is. It can be, and in some countries it is more, in the others it is less related to the politics. It is true that governments, they present those candidates. We have had situations in which the decision on who is going to be a judge among those three candidates is done by the Parliamentary Assembly of the Council of Europe. So this shows connection between the European Court of Human Rights and the Council of Europe. It is Parliamentary Assembly of the Council of Europe. It is it is an assembly composed of the delegates of the parliaments of the member states. So members of the Parliamentary Assembly are actually MPs, members of parliament in the member states. They're not directly elected by European citizens to be members of the Parliamentary Assembly. This is why it's called Parliamentary Assembly, in contrast to the European Parliament of the European Union, which is directly elected by the member states, by the citizens of the member states. So here, it is a body which is composed of the delegations. They're delegates of their own parliaments. So political figures, for sure. You would say it's a politicized process. And there is lots of lobbying in the process of appointment of. There is a political input in the moment of the presentation of the candidates, in the selection of the candidates, and there is then there is also a political input in the decision which is taken. More concretely, who will be the judge among those candidates, among those three candidates. However, there are also some intermediate bodies, Council of Europe bodies, between these two beginnings and ends of the process. So there is, first of all, a sort of consultative body composed of the former judges of the European Court of Human Rights, which is the first body to see who are the three candidates proposed by the member state. And they make sure on their side that these non-written rules are observed. So, first of all, that there is a gender balance. Secondly, that there is a balance in weight, in terms of the weight of the candidates. So that the three candidates are relatively of the same weight. Why? Because of the same weight. Why the same way? Because if you appoint, for example, one constitutional court judge who is at the same time a law professor, who speaks English and maybe even French, and then you put two attorneys who have no experience, no knowledge of languages, the languages are one of the criterion as well, which is stipulated in the rules. Who have no particular practice in human rights case law, it is obvious that these three candidates are not of the same weight, and hence that the Parliamentary Assembly is tied by the decision of the government to actually present this judge professor as a candidate. So in that sense, there has to be that kind of balance. And also, if there are also some other unwritten rules. For example, this consultative committee of judges, they prefer not to have Council of Europe agents as candidates. So they don't want the Council of Europe agents, those, for example, working in the secretariat of our called registry, the lawyers. So there is an army of lawyers actually helping these judges. So these judges could not do much without the help of the hundreds and hundreds of lawyers who come from the member states and who help them in drafting of the judgments. The judges, they draft the judgments, but these lawyers, they do research for them, and they, since they are the judges are appointed for a limited period of time. These lawyers who stay there during their good behavior until they retire actually are a sort of institutional memory of this court. So their weight is also, in terms of development of the case law, is also relevant. And so the judges, they don't want to have agents, these agents from the registry, being candidates for the judgeship, simply because, again, there would be, on one side, and there are various reasons for that. Maybe there is no need right now to enter into those details, but this is very interesting, this whole process. And then there is another body. This is why I'm shortening the presentation. There is another body, which is a judicial committee body within the Council of Europe, which is a committee to the Parliamentary Assembly, composed of those who follow the work of the European Court of Human Rights, and they also have their weight in the selection of the judges, in the sense that judges, before the vote is done by the Parliamentary Assembly, these candidates for the judges, they come for the interview before this committee of the Council of Europe. And so that committee, on the basis of that interview and on the basis of the CV of the judges, that committee, which is composed of the specialists in the field, they make their list of the priority and the list of preferences when it comes to who should be actually the appointed candidate. And very often, in most of the cases, this Parliamentary Assembly follows the order of the preferences of this specialized committee. But there are situations in which it is not respected. So there is that part. There are situations in which the consultative body of judges, former judges of the European Court of Human Rights, returns that list to the member states because they are not happy with the respect of those rules which I have mentioned, and not once but 2 times or even 3 times. What you have to take into account that after a while, when this body realizes that the member state is very stubborn and unwilling to obey, that body cannot continue returning that list, but after a while it just accepts the list as it is and it transmits it to other instances within the Council of Europe. It happens as well that in that later stage, these bodies react, and that list is returned, for example, as a result of the objections of this specialized committee of the Council of Europe, of the Parliamentary Assembly. So it is, on one side, a process which is initiated by a political body, which is government, or it may be that it is the national parliaments. It all depends on the national regulation, whether it's going to be government or national parliaments who will decide who the 3 candidates would be. At the end of the process, it's also Parliamentary Assembly of the Council of Europe. So that is also, you may see it as a political, as a sort of involvement, engagement of politicians and of politics in this whole process. But in between, there are these corrective mechanisms and corrective bodies. Also, what we also have to understand is that in the beginning, it was absolutely unthinkable not to appoint true experts in this field. In the field of human rights law, in the field of international public law, these were the 2 most important fields. Also, other knowledge of positive law when it comes to criminal procedure, civil procedure, is also very much relevant. And criminal law as well, private law as well may be important in certain fields. So in the beginning and nowadays as well, a great majority of judges are experts in these fields, but one has to admit that in some cases, in cases of certain countries, there is also a certain lowering of the standards. For example, younger lawyers are appointed as judges. When I say younger lawyers, I mean lawyers who are in their mid-careers, whereas before it would usually be the persons who were at the end of their careers. This would be seen, and this was seen as the crown of one's career. And this lowering of the age is not good, for example, because it it puts these candidates at these judges at a very difficult position, meaning a position in which they have to think what they would do after the end of their mandate in the court, in the European Court of Human Rights. So if you're not going directly to the retirement after the end of your mandate, you may be susceptible to more pressure coming from either your own state or some other states, because you as a judge, within your chamber of 7 judges, you decide on the cases, and you may be susceptible to pressures coming maybe from the parties, maybe from the government. So because the system functions in the way that individuals, after exhausting their domestic remedies in the legal system, in which for which they claim that it violated their rights, after exhausting domestic or ordinary domestic remedies, and within the period of 4 months after their final after the final judgment was rendered to them, they may file an application before the European Court of Human Rights. So these are the cases in which individuals attack the states, and this is why it is always we have the name of the individual who brings the application before the court, and in the name of that judgment is always also the name of the state against which the case is brought. So McCann versus United Kingdom, or Initiative of Youth for Human Rights versus Serbia, for example. So it can be both individuals, and it can be also legal entities who can bring cases before the courts against the member states. And it can also be, but that's very rare, interstate applications. So a state may bring an application against another state, but these instances are not so often. Jelena, yes.
Just to check if I understood you right. So the rule that there should be among candidates, both male and female candidates, that applies to all member countries, yes. Or is that just okay?
Yeah, it applies to all member countries.
Okay, because I was thinking in a sense, because if it's like a even little bit political decision, then some political options may not choose to candidate women. But if it's like a must, then
it's a must. But at the same time, it's there are women who also share the views of those who do not really protect the rights of other women. If you want, who do not think in those terms. They think in strictly political terms. They're very career oriented. They're very those who think in a strategic way that I mentioned last time, in a very distorted meaning of the strategic considerations, like just thinking, what would help further their career. So they're not. So that doesn't appear so much as an obstacle, but overall, it has certainly helped in terms, and what this is important in the context of our course, feminist judgments. It has helped overall the increase of the number of the female judges in the court, and also just like with any person, you may forget about certain rule, or you may not be aware of the rule and of its value. But when someone tells you this is a rule and you should respect it, you interiorize it and you really take it as a must. And you then try to get the best who could serve that rule. So there are, just like with, in also with the governments and political parties, there are those who are ready to follow the rule and those who are ready to abuse the rule. There is that possibility as well. It cannot be excluded. But this is in terms of numbers, in terms of pure statistics, it is respected. The women are there as candidates, and also they're there as judges. Serbia, for example, so far has never had a female judge in the European Court of Human Rights. But for example, Croatia.
Yeah, I think that Croatia
has had 2 female judges. Now Croatia has a male judge, for example, but it has had 2 female judges, whereas Serbia has, for example, has had so far 3 male judges. In the region of former Yugoslavia, for example, Macedonia also had 2 female judges. And I have to tell you, all those female judges were absolutely excellent in performing their duties. Also, they have been presidents of the sections. These female judges that I'm referring to from Macedonia and from Croatia, they have been presidents of the sections, which is an important status, to be president of a chamber of 7 judges. And some of them have also been vice presidents of the court. Montenegro currently has a female judge who is the vice president of the court. Formerly it had a male judge. So if we disregard Serbia and we take the region, we can say that the region of former Yugoslavia is shows that this rule can be applied in the best interest of the protection of human rights and including gender equality. Yeah. Serbia is, I would say, not the best example, but this is again raising another issue, and that is to what extent there is a culture of human rights, and even if there is no proper culture of human rights, to what extent, as I said, governments, even if there is no overall culture of human rights, to what extent the governments are nevertheless committed to further that culture of human rights, to try to change the bad manners and the bad habits, and to try to develop that culture if it is not present. So in that sense, it has given good results, as I said, overall, looking this period of couple of decades of the application of the convention in this area, in this region. Yes, it can be, as I said, the gender equality not only is reflected in the selection of the candidates, but also in the appointment of the judges. This is to show that the system from inside works as a sort of a constitutional system, and the European Court of Human Rights acts as a sort of constitutional court. What you have to take into account is the status of the convention case law, of the case law of the court, and the effects which it produces in the member states' legal system. So the first is the question of the status, and the second is the question of the effects of that case law. The status is whether the question of status refers to the issue of the position of that case law, first of all, the convention, whether it has a supra-constitutional, constitutional, or if infra-constitutional status. If it has infra-constitutional status, whether it is supra-legislative, or it has a legislative or infra-legislative status. So this is a question of the status of the convention itself, European Convention on Human Rights, and that very much depends on the relationship between international and domestic law and domestic legal systems. And you have maybe been dealing with these topics in the context of international law and international and European law, because this is a question of how the domestic legal system finds the position of international law within itself. And you know that, to simplify it, we have monist and dualist systems of the relationship between international and domestic legal systems. Nowadays, the monist system implies the prevalence of international law over domestic law, whereas the dualist system implies that international law has its sphere of application and the domestic legal system has its sphere of application. Well, thanks to the practice of the European Court of Human Rights, the convention gained definitely a supra-legislative status. So, European Court of Human Rights considers that convention has a supra-legislative status, and in some instances, the European Court of Human Rights has rendered judgments which affect the constitutions of the member states. So you may consider actually the convention to have even a supra-constitutional status, so that constitutions of the member states have to put themselves in the conformity with the convention. The court has and the whole system has been confronted to certain challenges in this context, both by very developed and less developed member states in terms of a rule of law and democracy tradition. So, for example, there are instances in which the European Court of Human Rights has found that United Kingdom has violated the convention, and that election law in the United Kingdom has to be amended due to the fact that United Kingdom election law does not allow for the prisoners to vote. It's a famous Hearst versus United Kingdom judgment, and European and irrespective of the reason why they were condemned to the prison sentence. So the European Court of Human Rights said that the blanket prohibition on all prisoners of the right of prisoners to vote is a violation of the European Convention on Human Rights. And also in the context of election law, a judgment of Sejdić and Finci versus Bosnia, and then just like with Hearst versus United Kingdom, there are many other judgments which were adopted as a result of non-application of this case by the United Kingdom, and also of this case by Bosnia and Herzegovina. Sejdić and Finci is a famous judgment known for the fact that as a result of the fact that Bosnian electoral system does not allow for those who are not members of the three constitutive people to be candidates for the members of the presidency of Bosnia and Herzegovina. So this case was brought by one person who is of Roma origin and one person who is of Jewish origin. And they said, look, our question of discrimination was raised. It was violated, and that this was a violation of the convention with respect to the ethnic origins, that everyone is equal. We will quote later on Article 14 of the convention, that no discrimination is possible on the basis of ethnic origin. And this was exactly the case of violation on the basis of ethnic origin.
When was
sorry?
When was that case?
The Sejdić and Finci was in 2010, let's say.
Wow.
Yeah. And first versus United Kingdom is even older than that. But this is, this is a question of these are very delicate issues. This is a Dayton Peace Agreement, ended the war in Bosnia and Herzegovina. So, it's unpacking that system, This was taken into account by certain judges if you read the dissenting opinions. So that's another important aspect of this decision making in the European Court of Human Rights, that judges have right to dissenting opinions and right to concurring opinions. And so the dissenters may point out to the weaknesses of the judgment, which overall contributes to the quality of the judgments, because if you in the majority know that there will be a minority criticizing you, you will provide the best possible arguments you can find. And this is a part of the transparency of the work of the European Court of Human Rights and the quality which is certainly very much appreciated. For example, in contrast to the Court of Justice of the European Union, where there are no dissenting and concurring opinions. So there is less of the transparency in that sense. And sometimes we criticize the judgments of the Court of Justice of the European Union, so of the Luxembourg Court, as being not as of the same quality in the argumentative sense as the judgments of the Strasbourg Court. So I gave two exceptional cases, also two cases where the European Court of Human Rights touched upon some very sensitive constitutional issues and issues relating to the political system of the member states. But overall looking, the convention has, as I said, supra-legislative status. It is considered that it has a status which is higher of the status of the ordinary laws, and that ordinary laws have to be in conformity with not just the convention, but with the court's case law. So this is very important because, as you will see, the provisions of the convention are very limited. It's an international document. It's not like a constitution. They were very delicate in choosing the words. Those words are very there was the choice of the words was very sensitive. It was a very sophisticated process of drafting the convention, and so there are so many words in the convention itself. We could say it's a skeleton, but the body, the flesh of that convention case law comes from the exactly practice of the European Court of Human Rights. It brings the flesh to that skeleton, which makes now the body of the convention case law. So the court has developed its case law. It considers that the case law has a supra-legislative force, and hence it obliges who are those who are the bearers of the duty of respect of the convention case law. It is the legislative bodies of the member states, it is the executive bodies of the member states, and the judiciary of the member states. As a result of that judgment of the European Court of Human Rights, an individual may not just receive damages, a compensation for the right which was violated, but an individual may reopen the proceedings in the member states in case, for example, the right to fair trial was violated. And as a result of the violation of the right to fair trial, maybe someone was punished, someone was sentenced or without a valid reason, or someone was detained without a valid reason. Anyway, if it is a case of a judgment which was rendered and which could have been the merits of which could have been different if the convention case law was respected, everyone who applied before the court and with respect to whom the violation was established, technically has a possibility, and that is also used, to reopen the proceedings in the member states and to have a new trial, to have a new proceedings in order for the judicial truth to be established in that concrete case. So the convention case law has to be respected in the process of the drafting of the new legislation. It has to be taken into account and it has to be respected. And if it is not respected and the violation is established as a result of the non-respect of the case law, not by the judge, but by the legislator, then that piece of legislation has to be amended. And for example, Serbia gives a good example of that kind of exchange between the two levels when it comes to some of the most important cases which come from Serbia, and they are related to right to fair trial, especially right to have timely proceedings, and also with respect to right to property. And there has been a true dialogue between the European Court of Human Rights and the Constitutional Court of Serbia with respect to some of those systemic types of violations in this respect. And the European Court of Human Rights, as a result of the judgments of the European Court of Human Rights, the Constitutional Court of Serbia amended its case law in order to be in compliance with the case law of the European Court of Human Rights. And also our legislation was amended when it was necessary, when it was needed, in order to be put into compliance with the convention case law. This shows that we can say, when it comes to the effects of the convention case law, we can say that it has a direct and indirect effect, in the sense that when a judgment is rendered against the member state, that member state has to comply with that judgment, either by, depending on what the case was about, either by amending its legislation or by reopening of the proceedings, or for sure by compensating that individual whose right was violated. But the convention case law has also an indirect effect in the sense that the case law adopted with respect to other countries also bind every other country in the system. So even if it is a judgment against Germany or against Italy, for example, questions of fair trial and questions of timely proceedings, was very much developed on the basis of the deficiencies of the Italian system. Some improvements were made in Italy, the court validated those improvements, and then it was expected from other countries having the similar problems with those with lengthy proceedings in their legal systems. They had an obligation to comply with these standards established, for example, with respect to Italy, or in some other instances when it comes to this all concerns, so to say, systemic violations, when there is, and we call this also sometimes pilot judgments, when the court adopts a judgment which serves as a pilot, as a guidance to the member state to render all other judgments of the similar facts and the similar law when the law is similar to be applied and the facts are similar, to follow that judgment of the European Court of Human Rights as a pilot judgment. So we can say that there is a sort of a precedent, that the rule of precedent applies. This is why we have within other programs of our Faculty of Law in Belgrade, we have just the courses on the European human rights law, where we elaborate and explain all aspects of that case law with respect to all the convention articles. Here we speak about it in the context of the gender equality. So to wrap up before the break, the point is that European Convention, European human rights case law has a supra-legislative force when it comes to its statutes, and when it comes to its effects, it has both direct and indirect effect on the one has to admit once again that this has been a result of readiness, of willingness of the member states and their internal bodies, especially of the judiciary, to comply with these standards of the European Court of Human Rights. So without the dialogue between the two levels, there would not have been this sort of progress and achievement in the statutes and effects of the convention case law. So this is just a very, very, very brief introduction in what the European system of human rights protection is about. Just to show you its relevance, nowadays judgments of the European Court of Human Rights are regularly quoted in the member states, in all member states, and European Court of Human Rights case law is a part of the curricula of the law faculties, as you can see from our course as well. So it has gained a very important status, not just in terms of the legal source of human rights law, but also it has been more and more embraced and adopted in the culture of the member states. And to finish with this final remark, this is why everything that I'm telling you about the present state of development of the relationships between the Council of Europe member states, and also what I mentioned last week, the letter which the member states have issued with respect to the which they have addressed to the European Court of Human Rights to sort of criticize its case law. It is absolutely unprecedented, and it is in a sharp, once again I repeat it, in a sharp contrast with what has been the case for decades and decades now after the Second World War. Okay, maybe do you have some more questions or comments? If not, I suggest we make a break of 10-15 minutes and then we continue afterwards. Thank you.
Thank you.
Welcome.
Profesore,
Da, kažete.
nešto da vas pitam, sam sekund. Mogu nešto da vas pitam dok smo na pauzi kratko? Konsultovala sam se sa profesorkom Krstić, pisala sam je da je pitam čisto da mi preporuči otprilike koga bih mogla da kontaktiram da mi bude mentorka za pisanje master rada, jer mi treba neko ko ima iskustva u oblasti parlamentarizma, da tako kažem. Jer razmišljam da spojim posao i master i radila bih nešto na tu temu, jer zapravo na poslu sad radim dosta stvari vezano za gender teme. Prošle godine je OEBS sa ODIR-om radio taj gender audit parlamenta našeg i ove godine bi trebalo da radimo na gender action planu, pošto je radim na tom parliamentary support programu. I između ostalog, evo danas sam baš imala sastanak sa jednom ekspertkinjom, isto ćemo raditi ove godine i na temi rodno odgovornog budžetiranja isto sa parlamentom, tako da nekako prepliću mi se te dve teme i onda sam razmišljala da je možda najbolje da i master rad radim na tu temu, nekako to me najviše zanima i sve. Pa mi je profesorka Krstić preporučila da pričam sa vama i sa profesorom Radulovićem, ja mislim da se prezve njega ne znam, i čisto da vidim, mislim, nemam konkretno još naslov i kao nisam, ali imam možda neke ideje, svakako ima vremena i to sam htjela da vas pitam da li biste vi bili zainteresovani i da li ste prava adresa, da li ste...
Pa da vam kažem da, ja mislim da je dobro da birate teme koje imaju veze sa vašom sa trenutnim poslom i koje u tom smislu su kompatibilne, tako da maksimalno vam koriste i da služe jedno drugome. I dakle, to je dobar pristup pod jedan. A pod dva, može, ako vaša tema bude više naginjala ka parlamentarizmu, onda bih mogu ja da, bilo bi prirodno da vam budem ja. Ako je tema više naginje ka rodnom budžetiranju, onda bolje da to bude kolega Branko Radulović.
Ne bih rodno budžetiranje radim sad na poslu, ali ne bih se na to usmerila. Ja sam više razmišljala, voljela bih da moj master rad bude više kao neki research i nekako razmišljala sam možda da bude kao da radim istraživanje uticaj internacionalnih organizacija na parlament NSRS, Narodnu skupštinu Republike Srbije, u procesu usvajanja tih rodnih politika i svega toga, da mi to, pa onda možda baš da se fokusiram, na primjer, na OEPS, kao da bude OSCE case, ali to moram da vidim sa njima da li smem da radim, tako nešto.
Ako morate da vidite s njima, zato što možete imati mislim, ti stavovi koji tu zauzmete, da postoji ta vrsta, da kažemo, disclaimera.
To mi je,
da, vidite s njima, razmislite, ja sam tu svakako, mislim, zakazat ćemo konsultacije, mogu biti online konsultacije i onda ćemo da vidimo prosto, dogovorili bismo se oko teme, strukture i tako sve.
Druga stvar koju sam razmišljala, mislim nešto to u vezi sa gender sensitive parlamentima, jer ja voljela bih da bude više u formi istraživanja, zato što sam davnih dana, prvi posao mi je bio u CRTI, pa sam radila na otvorenom parlamentu i tamo sam stvarno radila dosta istraživanja. Jedno od istraživanja je bilo i žene u parlamentu i bilo mi je to baš tad, mislim, vrlo inspirativna tema, tako da bih voljela isto i sad nešto u tom pravcu.
Možemo da porazgovaramo tako. Ima tih tema koje su važne, mislim, govorit ćemo o tim temama inače na ovom kursu, na human rights law i tako dalje, political empowerment of women. Znači, biće to je svakako tema uloga žena u procesu donošenja ustava, dakle to je jedna stvar, u radu parlamenta, dakle to apsolutno je nešto se uklapa naravno, ali vidite šta možete da se nešto, da ne bude u koliziji sa vašim profesionalnim...
To svakako i nešto isto, zato mi treba savjet nekoga, jer nešto što je realno, jer trenutno mnoge stvari nisu realne. Mi trenutno imamo žensku parlamentarnu mrežu koja više ne funkcioniše i ne radi se.
Da. Pa mislim da to treba, da.
Onda imamo mnoge stvari...
Da, zakažemo konsultacije pa ćemo onda porazgovarati. A isto mislim da ne treba da se bavite sad nečim što će biti neka statistika, mislim samo neka statistika koja treba da uopšte ne odražava realnost. Da. Što se tiče statistike ne stojimo loše, ali što se tiče propisa ne stojimo loše, ali šta je sa primjerom? Tako da...
Ok, dobro, ništa, ja ću još da razmišljam o tome i da pustim još ovo malo predmeti da idu, da slušam izborne i to, pa ću onda kad budem, napravit ću neki spisak ideja, pa ću vam pisati, ok.
Dogovorim, važno.
Hvala.
Hvala.
You've revealed something very important to me here.
Okay, I suggest that we continue with the class. I hope that you can see the presentation which I'm sharing with you.
We can see it, Professor.
Okay, thank you very much, Alexander, for the reply. So we were talking of some principles related to the status and effect of the European Convention on Human Rights. Now we will be talking about the basis of the European Convention on Human Rights anti-discrimination law, and we will speak of the typical cases of gender equality. I decided to now pass to the presentation because it somehow limits me in the talk, and the time is limited, so we should better stick to it. We talked about the status and effect of the European Convention on Human Rights. Now let's go to the basis of the anti-discrimination law. As you'll see, the cases of gender equality appear in different contexts. The domestic violence cases when it comes to gender equality are the most numerous. But it is also there are also cases concerning age of retirement, cases concerning amount of compensation awarded for medical interventions causing error. Also, ineligibility for a stay of execution of one's prison sentence and right to respect private family life when it is a question of sex raised. Parental leave and parental leave allowances, the differences between men and women. Prison regime with regard to the right to prison leave, again, differences between men and women, and termination of widowers' pension. So these are the, so to say, most often cases involving gender equality. We can add to these list also religious related cases related to the wearing of the religious symbols and religious clothing, and we will discuss about that set of cases in our next class next week. So these are the context and situations in which gender is raised. And these, all of these contexts and all of these cases lead, or most of them led to the establishment of the violation of the Convention by the European Court of Human Rights. And not only in respect of the, if it is a question of domestic violence, not only with respect to right to life, Article 2, and prohibition of torture, inhuman and degrading treatment, Article 3, but also with respect to Article 14 of the Convention. So, not only that the courts found that the life was not respected, or that physical integrity was not respected, but the court also found that this respect was the consequence of the discriminatory behavior of those who are in the position of power. In general, this concerns the judiciary, the prosecutor's office, the police officers who do not react appropriately and timely. But this kind of these violations established by the court also pinpoint to certain traditions and certain cultural issues which impose by themselves the differences of treatment between men and women. And in another Turkish case related to inability at that time, the case was rendered in 2004 about the inability of women in family law issues to keep their maiden name instead of the obligation to take the husband's name. the surname. The court found that these kind of laws, which are result of the practices which are discriminatory, is types of violation of the European Convention. So let's go back to what the Convention says and how the court interprets it. Article 14 of the Convention is very, as you can see, very brief, or very limited in its wording. The enjoyment of the rights and freedoms set forth in the Convention shall be secured without discrimination on any ground such as sex, race, color, religion, political or other opinion, national or social origin, association with the minority, property, birth or other status. So this is these wordings of the Convention are very scarce. They're very limited. Basically, there is a principle of discrimination, that the principle of non-discrimination. The discrimination will not be allowed, secured, or on any grounds. And then we have the list of those grounds.
And there is no gender.
Sorry? Yeah, there is no.
There is no gender.
There is no. This is a good point. Yeah, there is no gender. There is reference to sex, and there is also reference to other status. So I'll come to this point of yours, which is very right. But not only there is no gender. Generally, the Convention says that the enjoyment of the rights and freedoms set forth in the Convention shall be secured without discrimination. So it doesn't explain what is the discrimination, what is the test of discrimination, what are the standards of the establishment of discrimination. Also, you can see that the Convention initially refers to the enjoyment of the rights and freedoms set forth in the Convention. So only those, with respect to those rights and freedoms set forth in the Convention, does it prohibit discrimination. And rights and freedoms set forth in the Convention are civil and political in nature. The only right which is there are some rights which are civil and political, and also they overlap with some other economic and social rights or educational rights. But that is very limited once again, like right to property, like right to establish trade unions, like right of parents to have the education for their children. So that is these are very limited non-civil and political rights, and also they are civil and political in themselves. In that sense, the number of the rights respect to which the principle of non-discrimination, the prohibition of discrimination applies, is in that sense limited. Yes, Yana.
Sorry, I'm boring today with questions, but I feel inspired.
Mm-hmm. No. Sure.
I have one case to ask you. So if, for example, a person applies to work in some firm or NGO, let's say NGO, and the politics of that NGO is that no one who was previously involved in some political party cannot be employed at that NGO. And they refuse that person because of the involvement with the political party or just membership. Mm-hmm. Is that discrimination in this case?
First of all, in the context of the European Convention, if you're asking me in the context of the European Convention, there is also Serbian law on anti-discrimination, which is much more elaborate than the Convention itself. You have to, we have to also remind, and we have to point out that a protocol was adopted to the Convention, which establishes, which changes the wording of this Article 14, introducing that the enjoyment of rights and freedoms set forth, the section of the principle of non-discrimination applies to other rights and freedoms set forth in the domestic legislation. Mm-hmm. So this is not nowadays. This that has been the scope of the application of the non-discrimination law has been broadened. With respect to your question, the discrimination may appear both by an action of public authority and non-public authority. The discrimination may be committed both by an individual and by a legal entity. And so, in the context of a possible employment, as there is in principle right to be employed, as a right to, which implies a right to be, if nothing else, if not more, right to have your candidature, your CV and your request for employment considered on an equal footing with everyone else. There is, in these kind of issues, when you, not as a declared rule, but as a practice, do not take into account, discard those who are members of a trade union or a political party, or who have taken a political stance, even without being members of this and that organization, but just by making certain statements which are political, yes, which are political in nature, which express political views of that person. This may be considered as a case of discrimination. Now, the issue may be how to prove it. This is another question, and this becomes more complicated. If then you have to take into account what were the qualifications of other candidates. If this candidate was outstandingly better than anyone else, then it will be a clear case of discrimination on the basis of, or it may be needed to prove it additionally. If you can then have some kind of statistics showing that systematically people with political views are not employed, or this particular type of political views are not employed, and it may be an additional evidence of discrimination in that case. So, yes, it is something that could be considered as a discrimination in principle. Yeah? So we see that the convention initially was very limited in its wording. Later on, once again, by protocol, it was extended, the scope of its application. So not only with respect to the convention case law, not only with respect to the convention rights and freedoms, but also with respect to other rights and freedoms guaranteed in the given legal system. But that is it. Not more, not more than this. Not much, actually, if you don't have a court which is committed to the furthering of convention rights. And we were lucky, we had a court which was ready to further issues of gender equality and also to fight against the discrimination in general. But at the same time, what I omitted to mention in my previous lecture, in the previous part of the lecture, the European Court of Human Rights is a court for 46 states of Europe. And these countries have different histories, different pasts in terms of legal and political systems, in terms of cultures and traditions, in terms of religious orientations and all other types of orientations that individuals may have. The weight of religion is not the same in all of them. As some are more secular, some are less secular. In general, the traditions of the countries, of the member states, are different, and the court has to, when adopting a decision, when it adopts a judgment, the court has to take into account that judgment is supposed to be applied in, as I said, through the principles of through the statutes of the convention, case law, and through the nature of its effect. It has to take into account that that judgment has to find its place in every state of the Council of Europe. So when the court finds that there is a consensus among member states with respect to enjoyment and understanding of certain rights, it will go further. It will definitely enshrine, verify, apply that kind of consensus. Or it doesn't mean that all member states have to be on the same side. If there is an overwhelming majority, the court will adopt that position as its own. However, in controversial issues, in controversial cases, and those are cases of, it may be cases which concern religious or issues related to religious or private morale of people, questions which relate to individual consciousness. The court is there when it comes to these sophisticated issues, very controversial, even in the member states themselves, in one particular member state, or maybe in many of them, or maybe in all of them. The court will then be on the position that member states enjoy larger margin of maneuvering. So this is the term which the court applies: the margin of application, the margin of maneuvering when applying the convention. The more there is a consensus among the member states with respect to the application of the convention, the court is ready to be proactive in that field. The less there is a consensus, the court gives wider margin of appreciation to the member states. And so, following that philosophy, so this very much, as I said, both on one side limits proactiveness of the court, or it strengthens the proactiveness of the court. I'll give you examples. There are many examples of that kind of proactiveness of the court. For example, when it comes to freedom of expression, the court is very much proactive, and it considers that only. I'm deliberately giving examples which are outside of this course, just to give you that kind of wider perspective. For example, when it comes to freedom of expression, the court is especially proactive in advocating freedom of journalists and their professional right to, because it's also a matter of their profession, not just a matter of their taking positions, and not just a matter of criticizing the government. It's also their profession, and the court finds that journalists are watchdogs of democracy. So in that sense, the court is very much taking pro-journalist position, freedom of expression position. But, for example, when it comes to another political issue, which is the electoral system that I mentioned just briefly in the context of Hearst and Sejdić and Finci, although, for example, this is also a matter of electoral system, and the court showed a certain boldness and courage. In some other issues, for example, whether countries should have a majority or proportional electoral system, the problem with the majority electoral system being in the fact that single constituency majority system being in the fact that it is extremely disproportionate, and in that sense it potentially is discriminatory in its consequences, because it disproportionately favors bigger political parties over smaller political parties. The court has, since the member states are extremely split on these issues, and there are various practices in the member states, the court doesn't take a position on that issues, and the court considers that this is within the scope of the margin of appreciation of the member states. Or the questions of, as I said, of morale, of some very sensitive religious issues, such as the question of euthanasia, or the question of abortion, have not been, or the question of for example, conscientious objection is another interesting example. In the beginning, the court was of the position that conscientious objection with respect to the possibility not to serve the army or not to serve the army under the arms was not guaranteed by the convention. And then later on, as it established that there was a progress in the member states and that there was almost a consensus among the member states in the establishment of the right to conscientious objection with respect to our military service under arms. The European Court of Human Rights adopted a position, adopted a judgment against Turkey, in which it established that there was a violation of the convention because the right of conscientious objection was not respected. Whereas in many, many judgments before that, in the beginning, in the first decades of the application of the convention, the court was not on this position. So some moral or religiously sensitive issues may be a reason for the court to accord to the member states a wider margin of appreciation in the application of the convention. However, in the context of the anti-discrimination part of its case law, the court developed its certain standards, and it has been applying those standards consistently. First of all, the court considers that there must be a difference in treatment of persons in analogous or relevantly similar situations. So the court has to establish first that in a given case there is a difference in treatment of persons in analogous or relevantly similar situations, such as in these cases you have given, Jelena, where there are at least two or even more applicants, in which one applicant's candidature application was rejected. These are definitely people in similar or relevant, similar or analogous situations. And then it's not just that any difference in treatment would lead to establishment of discrimination. There has to be, if there is a difference in treatment, it is discriminatory if it has no objective and reasonable justification. So then we would have to look into on what this difference of treatment is based, and if there is no objective and reasonable justification, then we can come to the conclusion that there is a discrimination, provided also that the ground of discrimination is present. We will come to the grounds of discrimination. And what does it mean, no objective and reasonable justification? It means that differentiation or that difference in treatment does not pursue a legitimate aim, or if there is a legitimate aim, because that may be the case, there is a discrimination if there is no reasonable relationship of proportionality between the means employed and the aim sought to be realized. So sometimes there is a legitimate aim in differentiating two persons, two or more persons who are in analogous or relevantly similar situation. So there may be a legitimate reason to differentiate between them, but if that if this differentiation is disproportionate, then it's going to be a discrimination. So a legitimate distinction. So there is a distinction, and it is legitimate. It is okay if that distinction is not disproportionate. So we have to look into the circumstances of the case and to see whether that differentiation is proportionate or disproportionate. For example, exactly because of the weight of the religion, it is not considered as incompatible with the convention to have some churches and religious organizations having more favorable status than the other churches and religious organizations. If these churches and religious organizations are of traditional, have a long tradition in that society. But that favorable position may not imply that, for example, new religions and religious organizations, new churches and religious organizations cannot be established at all legally, or that that members of those new religions and new churches and religious organizations are prosecuted and punished. So these are all indications, or maybe the indications whether there is a proportionality in the relationship and in the differentiation. So differentiation may be legitimate, but it also has to be proportional. And once again, as I said, contracting states enjoy a certain margin of appreciation in assessing whether and to what extent differences in otherwise similar situations justify a difference in treatment. So they enjoy a certain margin of appreciation, and that margin of appreciation will be taken into account by the court. But even when there is a wide margin of appreciation, it doesn't mean by all it doesn't mean that the member state can do whatever it wants in that particular field. It just means that within the given context of these controversial issues, it has a wider margin of deciding what to do, simply because there is a plurality of systems in Europe, which is also a value in itself. There are different histories, different traditions, different cultures, and the court values them. The more there is plurality of solutions, that margin of appreciation will be wider in those cases in which that plurality is present. The less plurality there is, the margin will be narrowed. Narrower. And then not just, as I said, that there has to be a difference in treatment to establish a discrimination, that the difference in treatment, there is a discrimination if the difference in treatment is not legitimate. Even when it is legitimate, it may be a discrimination if it is disproportionate. But all of this is only provided that that difference in treatment is based on an identifiable objective or personal characteristics, or we say also status, by which individuals or groups are distinguishable from one another. Okay, so this is something which has to be taken into account when we speak of discrimination. Many people make a mistake. They see a difference of treatment which is not legitimate and which is disproportionate, and they claim immediately discrimination, although there may be no ground for discrimination in that particular case, because it is not based on an identifiable objective or personal characteristic. So it may be that in the given case someone with strong political attitudes and well known to everyone was not employed, but it may have been the consequence of the negligence of that committee, which was or of the persons who were responsible for reviewing the applications. So it does not presuppose by itself that there has been a discrimination. One has to show the difference of treatment is based on these identifiable, objective, and personal characteristics. Now, Jelena has raised the issue of absence of gender in the convention. It is true there is no reference to gender, and this was a surprise. This was the argument which was used to actually block the law on gender equality, which was with respect to which the court, the Constitutional Court, adopted the injunction.
You mean?
Sorry?
In Serbia.
Yeah, in Serbia, yes. Because the convention doesn't refer to gender, because the constitution doesn't refer to gender. So they said this is made up ground. This is not a ground which is based on a convention, on a constitution. Look at the text, and all that sort of stuff. Well, they disregard the fact that there is other statutes which is clearly stated in the convention and in the constitution. If we consider sex in this context to be significantly different than what gender is, but also another argument which refutes their position is the case law of the European Court of Human Rights, because it is true that the court initially used and more regularly used the word sex as the ground and sexual equality, but in its for the past 1 decade and a half, I would say it uses almost in on an equal footing these two terms, sex and gender. And you can't really, that may be also an interesting topic for some master paper, whether there is no, in my opinion, there's no significant understand in the court's case law, there is no significant distinction between sex and gender. So the court uses the term gender concomitantly to the term sex. So it uses both the term gender and the term sex. And we can also say that with the Istanbul Convention of 2011 and as I said, once again, the case law of the European Court of Human Rights, it comes out very clear that the court uses the term gender to pinpoint the differences in not the biological specificities of men and women, but in the roles which they perform in the society. So in that sense, yes, there is to a certain extent, in some cases, there is a use of these terms as if they are synonyms, but there are also cases in which the court pinpoints the necessity of having social equality between men and women in terms of their perception in the society, in terms of their roles in the society, in the family, at jobs, in the public places, which is not just related to the sexual differences, but more to these cultural differences, the differences which are established by the dominant views on what is the role of one sex and another. So exactly this word, this category of other statutes have generally been used to broaden the meaning and to broaden the potential list of the grounds. And sorry, I just got lost. And then the underlying philosophy of the court is that the advancement of gender equality is a major goal for the. This is the term which the court uses, gender equality. Yeah, the advancement of gender equality is a major goal for the member states of the Council of Europe, and very weighty reasons would have to be put forward before such a difference of treatment could be regarded as compatible with the convention. So by this it narrows down the margin of appreciation of the member states. In that sense, the injunction of the Constitutional Court is definitely disproportionate. It's absolutely disproportionate. There is no doubt about that. Maybe there is a legitimate aim with respect to certain provisions. I think we have talked about it in December at the course of Professor Dragica Vujadinović. So there are some issues which are not, for which, with respect to which that law or the administration is not still prepared for the application of that law. But this does not, and all of them related to the use of language, to the use of certain professional terms for the defining the professions and professional functions. But this is not a reason to disapply to the whole to order the disapplication of the whole law, the whole statute, pending the decision, the judgment of the Constitutional Court. And we knew from the very beginning that this would be the strategy of certain circles in the society to block the application of that law indirectly. So it's not the Parliament, it's the Constitutional Court, and then you cannot criticize the Constitutional Court because it looks like you're violating the rule of law, and etc., etc. So that's a kind of very cunning strategy on the side of those who were against it. But it was a strategy which was immediately revealed and brought to light. And here, the court, in the second point which I make, deriving from taking it out from the court's case law, the court says that references to traditions, general assumptions, or prevailing social attitudes in a particular country are insufficient justification for a difference in treatment on the grounds of sex. And now we come to an issue which is very much relevant for your case, which you brought, Jelena, and that is the burden of proof. So once the applicant has demonstrated a difference in treatment, it is for the government to show that it was justified. So this is the reference to the government is here because of the convention case law. It's about the relationship between individuals and the governments. But in your case, once the applicant in that employment case demonstrates a difference in treatment, it is for the employer to show that that difference of treatment was justified. So this burden of proof, which was again established through the convention case law, significantly advances the protection of gender equality, because then, or any other issue of equality when it comes to prohibition of discrimination, because once you demonstrate a difference in treatment which is not justified, it is on the other side to show why someone else was employed and not this person. So if there are no relevant arguments to show that difference in treatment, then you may further claim that that was the case of. But you have to also show. That part is not always easy to show. This is why statistics is used. When it comes to one person, it may be difficult to show. But if there are a number of issues, if there is another person with the same, well, that already shows that may have more chances for the success than one person. So this is why statistics is very often used in anti-discrimination law, and only when we have a number of issues of those who are in similar or analogous situations, who, with respect to whom there is a unfavorable application of the relevant law, and then there is, with respect to all those applicants who were not in a privileged position, there is something common, like a common ground of discrimination, some personal characteristic, identifiable, objective, etc. Then you may have more chances of proving a discrimination. So discrimination, in that sense, presupposes very often, not always, because when it comes to other types of discrimination, such as hate speech, you don't need any statistics to show that there has been a discrimination in those instances. Okay, so this is about the general standings of the European Court of Human Rights. Now let us look at some of the cases which have been which manifest this position of the European Court of Human Rights. The court establishes the violation of the convention with respect to some of the substantive articles, and at the same time it establishes that there has been a discrimination. So this is very important for showing that the court took into account the difference in treatment, and that was not justified, that it was disproportionate, and it was done in these type of cases on gender ground. The court did not just find violation with respect to right to life or prohibition of torture, but it also finds that this was because of the discriminatory behavior of the authorities. For example, in Opus versus Turkey, a very famous case, the applicant alleged that the Turkish authorities had failed to protect the right to life of her mother, who had been killed by the applicant's husband, and that they had been negligent in the face of repeated violence, death threats, and injury to which she herself had been subjected by him. She further complained about the lack of protection of women against domestic violence under Turkish domestic law. And the court found violation of Articles 2 and 3 and Article 14 in conjunction with Articles 2 and 3. So she lost her mother. In that sense, she was able to claim violation of Article 2 when a right to life is concerned. Only a close person to the person who lost her life can bring an application. And so it is with respect to her as a daughter that there has been a violation of right to life. And also she has been subjected to repeated violence by her husband at the time. And in that sense, the court found also that the prohibition of discrimination was not applied. So the court in that sense manifested its consistent, it applied its consistent case law when it comes to the of certain negligence in behavior of police officers, because of certain cultural which permits that type of violence, and which considers that what happens within the walls of one house is only relevant to those living in that house, and that it doesn't concern those who are outside. And you will very often see this kind of logic, even with respect to the acts of violence, individual and isolated acts of violence happening in public. People would just turn their blind eye, as we say, turn their back to some acts of verbal or even physical violence which are happening in front of them, because it is considered that this concerns only those who are directly involved in that kind of engagement. Yes, Joanna.
Yeah, we actually analyzed this case on feminist and political legal theories from different perspectives of feminist theories. And also we analyzed like the public and private sphere, and from the perspectives of radical feminism, liberal feminism, and intersectionalism, actually. So we are familiar with this case, actually. I know that it's a landmark. It was the first one, right?
It was a landmark. It was the first one in which the court took this very first of all, there is a. You want to add something, yeah? Okay. So there is a history to this position of the court when it comes to positive obligations of the state. So the issue of the positive obligation of the state, and not just a negative obligation, not to take away life, but to take everything which is in its powers to protect the life, comes from other type of cases which have nothing to do with gender equality. They have just to do with the cases of some individuals whose life was taken as a result of the kinds of crimes without the elements of the hate crimes, without any kind of particular discriminatory ground behind them. And so the court, like famous Osman versus United Kingdom case, where the court, or McCannon even before that versus United Kingdom, so cases where individuals lost their lives because of the fact that the state authorities, principally police, did not take in its everything that they had in their power, and everything that they could take into account in order to protect the lives. So they were informed of the risks that person was exposed to, but they didn't take any measures to protect that person. So there is a sort of building. There was a sort of building up of this position of the court when it comes to the positive obligation. And then there is also a very broad case law with respect to positive obligation in the field of Article 8, protection of private life, which also in conventional case law includes environmental protection, because environmental disasters, industrial disasters, etc., also may affect life directly, or may affect the physical integrity of people, or may have an indirect effect on life and physical integrity. And so in these instances, the court has developed a positive obligation of the state. Also in the context of freedom of expression, a positive obligation of the state when it comes to some repeated instances of violation of freedom of expression. A positive obligation of the state to prevent these kind of repeated violations of the right to freedom of expression. So there was a kind of history, and then the court has added gender equality to this issue, to this position. But as you can see, the case came only in 2009. Also, what has to be taken into account that for the court to take these kind of positions and for the court to be more proactive, there has to be cases. Someone has to bring those cases. You have to have also. This is why it is important to have NGOs who are engaged in providing help, assistance to those who suffered the violation of the convention, rights and freedoms. And also, it is important to have not just good prosecutors and judges, but also to have good attorneys, because it may be NGOs, it may be a good attorney who knows that there has been a violation of the convention, and not just the questions of length of proceedings, as this is the case in Serbia, a right to fair trial and some other aspects, and protection of property. Like, there are no other rights and freedoms except for these 2-3 which I mentioned. And then there is a whole other list of countries, whole list of cases very similar to Opens. For example, MG versus Turkey. The case concerned domestic violence experienced by the applicant during her marriage, the threats made against her following her divorce and the subsequent proceedings. In particular, the applicant criticized domestic authorities for failing to prevent the violence to which she had been subjected. She also complained of permanent and systematic discrimination with regard to violence against women in Turkey. Then Halime Kılıç versus Turkey, a case which concerned the death of the applicant's daughter, who was killed by her husband despite having lodged 4 complaints and obtained 3 protection orders and injunctions. Then Talpis versus Italy, so also outside of Turkey. The case concerned conjugal violence suffered by the applicant, which resulted in the murder of her son and her own attempted murder. Eremi and others versus the Republic of Moldova. The first applicant and her 2 daughters complained about the Moldovan authorities' failure to protect them from the violent and abusive behavior of their husband and father, a police officer. Balshan versus Romania. The applicant alleged that the authorities had failed to protect her from repeated domestic violence and to hold her husband accountable despite her numerous complaints. She also submitted that the authorities' tolerance of such acts of violence had made her feel debased and helpless. So these are all cases, I've deliberately taken out the most important ones and coming from also different countries, so that you can see how similar the circumstances are. And in that sense, if you have such a similar circumstances in so many different countries, it's like a plague. It's like a pandemic. You see that there is actually a systematic problem in a great part of Europe regarding the issues of domestic violence. And in that sense, that it is not surprised that in 2011 the Istanbul Convention was adopted in order to fight against the domestic violence. But these are not the only cases which are relevant in this context. In the context of gender equality, we have other cases, such as Pajak and others, versus Poland, a case which concerned 4 judges who complained about legislative amendments that had lowered the retirement age for judges from 67 to 60 for women and to 65 for men, and had made the continuation of a judge's duties after reaching retirement age conditional upon authorization by the Minister of Justice and by the National Council of the Judiciary. This is the court has established that there has been a violation of Article 6, the right to fair trial, and Article 14 in conjunction with Article 8. So all of this in conjunction with Article 8, because within the context of Article 8, right to private and family life, in this context, right to private life, that certain professional issues may be raised because of the fact that a profession is considered as something which is a part of the identity of the person. And in that sense, it may affect a private life of an individual. So this is a very, again, it is an example of a very proactive approach of the European Court of Human Rights, because there is no provision in the convention which can be directly related to the labor law issues, just like there is no provision of the convention that can be directly related to the environmental law issues. But through the concept of the private life, understood in a broader sense, implying either identity of the person or implying the health of the person, the court has adopted this approach that, as you can see, issues related to the employment and to the retirement age can be brought about. Also, this was in the context of a very reactive and very illiberal government, which was at the time in place in Poland, a Law and Justice Party of Kaczynski, which in many aspects has lowered the rule of law standards in Poland. And one of them was, this was the way, the lowering of the retirement age was actually a way for them to fill up the courts with new judges. By lowering by sending people to an early retirement, the new posts were created for those judges that they wanted to appoint, and not only that they did this for purely political reasons, for the sake of their own political reasons, but they also demonstrated a certain how should I say, certain position with regards to the issues of gender equality. So they made that kind of distinction, which the court found to be discriminatory between men and women. And then Carvalho Pinto de Sousa Moraes versus Portugal. A case concerned the decision of the Portuguese Supreme Administrative Court to reduce the amount of compensation awarded to the applicant, a 50-year-old woman suffering from gynecological complications as a result of a medical error. An operation in 1995 had left her in intense pain. I don't know what I meant here by incontinent, and with difficulties in having sexual relations. The applicant alleged in particular that the decision to reduce the amount of compensation was discriminatory because it had disregarded the importance of sex life for her as a woman. So that aspect of the gynecological intervention which she has had, which had an impact on her possibility of having sexual relations, was disregarded in the judgment of the Supreme Administrative Court, and she, in that sense, for that reason, she claimed the compensation, and she claimed also that the domestic authorities showed disrespect for her of the importance of sex life for her as a woman. And the court took this into account and established there was a violation of Article 14, so there was a discrimination in that sense, in conjunction with Article 8. Again, this broader application of Article 8, allowing for protection of health issues. And then Alexandru Enance versus Romania. This case concerned in particular a prisoner's complaint about discrimination on grounds of sex, stemming from the fact that under Romanian legislation, only convicted mothers of children under the age of 1 can obtain a stay of execution of their prison sentence until their child's first birthday. The application for a stay of execution of prison sentence lodged by the applicant, the father of a child under the age of 1, has been dismissed by the Romanian court on the grounds that the provision in had to be interpreted restrictively. The European Court found no discrimination, no violation of Article 14 in conjunction with Article 8, taking into account the specific nature of relationship, the difference in relationship between father and mother when it comes to the upbringing of children at that very early age. So the court considered that actually mother and father are not in a they are in a analogous similar position, but that the legitimate there was the legitimate aim in this case, and that is the nature of mother's involvement and the importance of mother's involvement for the upbringing of children at such an early age. And for that reason, the court found that there was no violation of Article 14 in conjunction with Article 8. And then Konstantin Markin versus Russia, another landmark judgment. Also, one of those judgments in which a specific reference to gender equality is made. This case concerned the refusal by the Russian authorities to grant the applicant a divorced radio intelligence operator in the armed forces parental leave. This man who was working in the military was refused parental leave. The applicant complained of a difference in treatment in relation to the female personnel of the armed forces and to civilian women. Basically, he was, because he was man, he was not allowed to have parental leave compared to the position of women, and the court found that there was a violation of Article 14 in conjunction with Article 8. The court is generally favorable to the exercise of parental responsibilities by the fathers, so as to allow for mothers to achieve their professional goals as a result of the fact that fathers can occupy with the children as well. And it is exactly in this context that the court used the term gender equality in order to refer to the stereotypes as to what are the roles of the fathers and mothers in society, and that the stereotypes about fathers having to be engaged only in activities outside of the house and business-related activities, whereas mothers are supposed to be engaged within the confines of the house and their domestic responsibilities and upbringing of the children. That those kind of stereotypes should be overcome, and that gender equality exactly implied that both parents, father and mother, can fulfill themselves in all their respective roles, men as fathers and mothers also in their own professions. And so the court has taken this position. There was a violation of Article 14 in conjunction with Article 8. Gruba and others versus Russia, a case which concerned the difference in entitlement to parental leave for male and female police officers. The four applicants had their requests for parental leave rejected, essentially because such leave could only be granted to a male police officer if his child had been left without the care of mother. They complained that the refusal to grant them parental leave had amounted to gender discrimination. And in a similar vein as it was the case with Konstantin Markin, the court here found the violation of Article 14 in conjunction with Article 8. Again, because of these differences in the statuses between men and women. Men were allowed to take parental leave as a police officer only if the child had been left without the care of a mother. This actually, this kind of difference in treatment in the legislation implied that mothers could always take a parental leave, and fathers could, whether there was a father or not, and even if there was a father present, and they could have taken the parental leave, whereas fathers were allowed to take parental leave only if the mothers were absent, if there was no care of mother. And again, this type of legislation brought to the light these differences in understandings of the role of men and women, that it was expected, it was considered, it is self-understood that men should be more engaged in the activities outside of the house, and that mothers should sacrifice some of their professional activities, let's say, or other social engagements for the sake of family obligations. So by finding violation of Article 14 in conjunction with Article 8, in this case, the court has supported the gender equality and the balance between the roles of men and women, both in the public, in the social life, in the professional life, and in the private family life. So these are the most significant cases relating to the gender equality in the practice of the European Court of Human Rights. There are some other interesting cases, and I have deliberately left them for our next class. And those are the cases involving religion and wearing of religious clothing. I have, since these are particularly, I would say, controversial cases, I wanted to leave them for our discussion, and I will, in the preparation of the next class, I will send you I will send you the 2 or 3 cases which I will ask you to read, so that you can have also a practical work for that class, and so that we can also have a discussion within that class, so that you can now, after certain perspective about the convention case law, about the discrimination, so you can take a look at some judgments, and we can then discuss on the example of those judgments how the court deals with the issues of discrimination, whether it deals with issues of discrimination or not. I mean, you will see that when it comes to religious issues, that we can consider the court's case law to be also conservative. I mean, everything which I presented so far seems to be very grounded in the domain of protection of gender equality. Well, we will see that we can, discuss these issues about gender equality, and that maybe the court is not always up to its expectations, and that there are serious critiques about the work of the court in some fields. Yeah. So much for today. Do you maybe have any questions or comments about this issue, the case law of the European Court of Human Rights with respect to gender equality? Okay, thank you. And I do remind my request to all of you to come and participate in the class, to be present here as much as it is possible, not just for my classes, but also for the classes of other of my colleagues within this program. Thank you once again, and then see you next week.
Thank you.
Thank you, Professor. Goodbye.
Bye-bye. See you.
Bye.
Laku noć.
Laku noć, Saifu.